Ms. Bernal, you're back in. So what are we able to do with your case?
We are asking for a judgment to terminate the tenancy here today. There's no legal argument to be made. This is a demand for possession that was made. The 30 days is up. It was properly served, and the defendant has had the opportunity to get counsel, and it's been adjourned for that reason. And so here we are today. And this is a situation where I see that the title on this case is Elizabeth Hadley. Ms. Hadley, it has authority as guardian of Joanne Tucker under letters of guardianship authorized by Judge Buck, and as trustee of the Joanne Davis Tucker Trust under a protective order also signed by Judge Buck. So she's acting in a fiduciary capacity for Ms. Tucker, and the house is to be sold to provide for Ms. Tucker's care. The defendant is her daughter and has refused to move out of the house. I did ask her today if she's made any progress with that to see if we could reach an agreement in that way. She has told me that she has not begun to move, and nor has she obtained counsel. At this point, there's no legal argument to be made. And I would ask that a judgment be entered terminating tenancy.
Ms. Harja, what is your legal basis for remaining?
I'm claiming proof of discovery and I'm disputing everything coming against me. I don't know why I am not allowed a public defender. I've never heard of such a thing.
Well, ma'am, this is not a criminal matter. This is a matter where you could seek legal assistance through legal aid, but this is not a criminal matter for a public defender. You've been given the opportunity to seek that. I'm looking at the notes here. So why haven't you?
Because I can't afford $6,000 or whatever dollars they want for a retainer fee. I have no
That's not
job.
what I asked, ma'am. That's not what I asked. That's you're going down the wrong avenue there, because legal aid doesn't cost anything. So all
I
right,
don't
well,
know that.
ma'am, I'm going to set the matter for trial ASAP. You have to have all of your documents presented, and if you're not able to proceed with trial at that time, a judgment will be entered at that time. But we are going to be proceeding with trial on an expedited basis, because this is a matter that's been sitting out there, and especially if it's a matter that's going to be having a problem with making sure that they have funding for the care of the owner. Well, then we need to move this forward. So I would urge you to move forward. And when I say we're moving this forward to trial ASAP, I mean, it's going to be very quickly. So just understand that. Set for trial ASAP, no pretrial.
And I was told I'm allowed 30 days after the trial.
No, you're not. But,
well,
again.
I need to get a lawyer then. This is all wrong.
No, it's not wrong. It's just the way the law is. And you've had plenty of opportunity to get a lawyer, so I would urge you to do so. You can leave the court. Good luck to you, ma'am.
I've struck out with a half dozen lawyers because they need money immediately.
Well, it might be the way you present it to them, but you might actually have an issue with reaching out to legal aid as well. But again, that is something that does not prevent the plaintiff from moving forward with their case. So as I indicated, this case will go to trial ASAP when you get the trial notice. If you don't appear, we'll do it by default. If you do appear, we'll take your proofs and we'll make a decision based on the proofs that you present, as well as what the proofs are that are presented by Ms. Bernal and her client. You're all set. You can leave the court. Good luck to you.
All right. Thank you.